Mr. Reardon, good morning.
Good morning, Your Honors. Attorney Theodore Reardon on behalf of Mr. Upton. With me today is my partner, Deborah Reardon, and Mr. Upton's family is in the audience. Your Honor, this case presents the interesting question of the Commonwealth charged Christopher Manaloulis with murder one, and then used him as its prime witness in 2 murder trials against his co-defendants. Then it reduced his charges to manslaughter, gave him a 12 to 15-year sentence instead of life, and cited in particular his cooperation in testifying in those 2 trials. Yet it maintains that there was never an agreement with Christopher Manaloulis. We would suggest to you, Your Honor, that under the Hill case, the fact that the charges were reduced and that he had a lesser sentence supports that there was indeed an agreement.
Well, it's not just the prosecutor who says there was no plea agreement. It's also the judge who was the trial judge, reviewing this on a motion for new trial, and his factual findings are pretty pointed in that regard.
Yes, but that's basically based on the prosecutor saying that he didn't have an agreement.
There's no affidavit from trial counsel, right?
From
Defense counsel.
From
Chris's counsel.
Chris's counsel. No, there isn't. And as a practical matter,
That's significant?
I'm sorry?
Isn't that significant?
Well, as a practical matter, Chris had an adverse position to Mr. Upton all along. And basically, there's no way the trial counsel would ever give an affidavit. Chris testified differently in his civil case later on. Counsel would have to basically give an affidavit explaining how and why Chris committed perjury in one of the trials, because he certainly did commit perjury in one of the trials. Counsel would never give that affidavit. But there is other evidence supporting that there was an agreement. In particular, Chris was held on, without bail for 9 months on a murder one indictment. The Commonwealth during that time had no idea of his father's complicity. He turned in his father. He exposed his father to a murder one indictment and a life sentence. He did that with no expectation of any kind of benefit to himself. He just gratuitously turned in his father. That doesn't make sense. There must have been some kind of implied agreement that he turned in his father.
Well, an agreement in his head. I mean, do you think he just had, there's also the possibility that he just thought, if I behave properly, perhaps I will get treated fairly?
I think that's very generous to suggest that, yes.
Okay. All right.
And the other evidence is this.
But the nature of an agreement is that both sides have to agree to it.
Yeah.
So if the prosecutor essentially says, listen, I'm not going to make an agreement with you. I'm going to basically, the only agreement I'm going to make with you is that I will not use what you say against you, and that I will consider your cooperation deciding how to proceed. And that's all I plan to offer. He had a choice then of essentially saying, okay, I'm going to refuse to cooperate and face a murder one indictment, or basically take his best chances. So why is that so implausible that the prosecutor simply said, I don't want a witness who will come with a promise of a manslaughter plea. I want somebody who will come without that promise, and therefore will have more credibility with the jury because the promise is not there, and I'm simply not going to give that promise.
Well, my response to that would be this. The Commonwealth is preparing for 2 murder trials. They're not putting Chris on trial. They're relying upon him as his main witness to succeed in prosecuting on 2 murder one cases. It's not implied when Chris is their main witness that if you're not on trial, Chris, that if you perform on these 2 cases, that we're going to give you some benefit at the end. I think clearly when Chris is testifying as the Commonwealth's main witness on these 2 cases, it must have been a wink and a nod that if you perform, in the end, because you're not in trial now, in the end, we're going to do something for you.
Well, let's assume you're right that it was implied. Is that enough? I mean, certainly he was cross-examined at trial on precisely those grounds to say, you need to testify in a way that the Commonwealth likes because they literally hold your life in their hands. Doesn't it have to be an express promise as opposed to an implied expectation or an implied promise?
Oh, no, the law is very clear that it does not need to be expressed, that it can be implied, it can be something less than written down, as long as there is some kind of understanding that there's going to be some benefit, which I would suggest to you when he's testifying for the Commonwealth in 2 cases, when he's got a murder one charge pending against himself, there's some kind of a wink and a nod that if you perform, well, you're going to end out
Well,
okay.
what's the wink and the nod? I mean, I don't know how far you're suggesting Commonwealth versus Hill goes, but it's not the content of the consciousness of Christopher, and I'll refer to him by first name to eliminate family complications, or what's in the prosecutor's mind. That's not a wink and a nod. A wink and a nod is some, even if it's subtle, some meeting of the minds. It's not just what they're hoping for themselves. It has to be more than that.
Oh, absolutely. And I would suggest you have that. Again, when the Commonwealth is preparing for these 2 murder trials, there must have been some kind of preparation sitting down with Chris.
So are you basically saying there's a circumstantial evidence standard we should apply here to whether there's an agreement?
Well, yes, but we also are buttressed by the fact that Attorney McLaughlin submitted an affidavit that during Trayfon's trial, that she overheard an ADA Manouk say that Chris was going to be getting a reduced sentence because of his testimony. And you couple that also with...
That wasn't the prosecutor in this case who
No, it
was
was not.
overheard saying that.
Correct.
And it could have just been a discussion about a possible second internally. I don't know what that does.
Well, according to Attorney McLaughlin, it was more than just a discussion. It was an assertion of fact.
You run into the same issue we started with in that Judge Nickerson didn't accept that as a factual finding, right?
He didn't, but I think we have to look at the developments since then that not only, well, correct, he did not, but I think we have to look also at Chris's civil testimony in which he acknowledged that indeed there was an agreement all along. I think all of it, to answer your question, Judge Cipher, yes, it is a circumstantial case, but there's a lot of circumstances here, and I think it all supports that.
All of that in front of the trial judge, Judge Nickerson, correct?
Yes, yes,
And now for you to prevail, we'd have to find that that finding was clearly erroneous, correct?
yes.
And you think it's clearly erroneous because of the circumstantial evidence that surrounded it?
Yes, yes. But that's not my only argument about the newly discovered evidence. There's also the fact that when Chris pled guilty to manslaughter, he acknowledged that he had homicidal intent in this case. And that's very significant because when this case was tried, it was on the posture of Chris was a 17-year-old, malleable, impressionable kid whose father threatened him that if he didn't do this act, that he was going to be sent away to military school. Also, he testified that he never had any intent to harm his uncle. He said, I saved my uncle from one murder attempt, and I stood ready on this occasion to save him if I could. He testified about how his intent was to save his cousin Haley, who had a murder threat against her, and that he agreed to steal jewelry in order to save his cousin.
Isn't it the same point that Justice Gaziano just raised, so you run into the same issue of Judge Nickerson's finding in that regard, along with that impeachment relative to the lack of a plea agreement was cumulative?
Well, I don't think this is just impeachment. This is a total recanting of Chris's testimony about what happened at the
Well,
trial.
what about the first point that the judge talks about what he thinks of the civil testimony?
Well, at this point here, I'm addressing the fact that he pled guilty to, Chris pled guilty.
Well, your point is that you can't reconcile the manslaughter plea with the trial testimony.
Yes, right. And the Commonwealth's entire case was based on this kid was innocent. He didn't do anything wrong. He had altruistic motives. He had never intended to harm anyone.
Well, not entire case. You've got the shell casings, the projectile, all matching to the defendant's gun that's found in his basement.
Yes, and as to that, defense counsel made the excellent argument at trial that, in fact, if Mr. Upton was guilty in this matter, he would have tossed the gun into the ocean. The fact that he didn't destroy the evidence is more consciousness of innocence than anything.
Help me a little bit with regard to Chris testified at trial that he did go into the home of the person who was shot and did potentially do an attempted robbery or attempted burglary.
Well, he said he was reconnoitering for a future one, which
He was going through the clothes looking for jewelry.
Yes, but not to steal them, just to see if they were there.
And if they were there, the plan was what?
Well, see, that's interesting because in his first testimony in Trayfon's trial, he testified that he was there to steal the jewelry. Defense counsel in Trayfon's trial pointed out, well, if you did that, your uncle, Aris, is going to know that you stole it, right? So now, in this trial, in Upton's trial, he changed his testimony. So now he said, oh no, I wasn't going to steal it. I was just going to see if the jewelry was there, and then we were going to come back another day. So he changed his testimony to cure the defect pointed out by Trayfon's defense counsel in the first trial.
So it's still a crime.
Well, at best, a conspiracy to come back and commit a burglary. But again, he made himself out to be innocent. No intent to harm in this case. But Mr. Upton's whole point in this trial was that Chris was a conniving prevaricator, that he's the one who committed this crime. And now his plea, admitting his homicidal intent, his manslaughter, it substantiates the defendant's position at trial in this case. And keep in mind, if Chris had told the truth in Mr. Upton's trial, then the charges should have been dismissed in their entirety against him. He had no homicidal conduct. The fact that he pled guilty to manslaughter proves that he lied in this case, in Mr. Upton's case.
But lied in a way that would help Mr. Upton?
Yes, because in admitting the homicide, it is consistent with the defendant's, Mr. Upton's trial theory that Chris is the one who committed this crime. Chris is the one who was responsible for this. Chris was not this innocent kid that he was made out to be during his trial. He's complicit in this matter.
I didn't see any reference in the briefs to a CSLI evidence. Was there any CSLI as to the location of the cell phones?
No.
I'd like to go back to Justice Kafker's question. I'm not so sure that we shouldn't think about the lack of an affidavit from Chris's counsel. That seems like a gaping hole.
Well, in response to that, Your Honor, I had requested an evidentiary hearing on the motion for new trial to have Chris's counsel testify, to have the DA explain why these, whether or not there was a quid pro quo. Why? What was when defense counsel referred to the DA as being a man of his word, Chris's plea hearing, defense counsel referred to the prosecutor as being a man of his word. Well, what word had he given? What promise had he kept?
Wasn't it pretty clear in context that referred to where Christopher was going to be serving his sentence? If you look at that statement in context, isn't it clear that that was what that meant?
I don't think so. I think the key word in that case is where the prosecutor said that there was never an open, quote, discussion about an agreement. But this gets back to whether or not there was some kind of implied agreement when Chris was testifying as the main witness in 2 murder trials. And there must have been some kind of trial preparation. When he's preparing to testify in these trials, there's no implicit understanding that in the end he's going to make out. There must have been.
So your view is that in where the prosecutor says, I'm going to make no promise to you except that I will not use your testimony against you, and that I will take into account all that you have done in deciding how to proceed. And if the defendant, or if in this case Chris, says, well, I think that if that happens, I will be able to plead to no more than manslaughter. And if the prosecutor essentially says, without saying it, that if he does what he's supposed to do, I think that that's probably what I will do, that suffices as an agreement that has to be viewed as a promise, reward, and inducement and furnished to the defense counsel?
Well, but that's not the only evidence in this case. Again, there's additional evidence where the defense counsel at Chris's plea hearing refers to the prosecutor as being a man of his word.
Right, we understand that, but I'm referring to sort of, I'm just trying to figure out what the obligation is. I mean, these are expectations, people expecting what they will do and what others will do. Is that sufficient to be treated as a promise, reward, or inducement?
I think that when Chris is testifying as the Commonwealth's main witness in 2 murder trials, it goes beyond a mere subjective expectation on Chris's part about that that he's going to receive a benefit in the end. I think all along there was a understanding implicit by the Commonwealth.
What about this situation? What if the Commonwealth has a strong case and they need to call somebody in Chris's position, or somebody in Christopher's position wants to testify? They don't really need the testimony, but they might be looking at a missing witness instruction if he's not called, or all sorts of issues. And they don't want to own that witness. They don't want to own the cross-examination that's going to take place. They don't want to have to carry that taint in their case. Are we supposed to, by definition, because the person testified, say that there must have been some sort of implied agreement that can be inferred from the conduct of testifying?
Well, that would be a different case, though, because in this case, the Commonwealth
But
would
what
have...
about that case? Would that be the situation that we're nonetheless supposed to infer some sort of a wink and a nod agreement?
If it's buttressed by additional facts such as we have in this case, yes.
So you keep saying there must have been some sort of agreement, but what we have here is Christopher testifying one way at the murder trials and then testifying in an opposite way at the civil trial, right? And then his change of plea. The motion judge, the trial judge, had all of that in front of him, and he weighed it. And, I mean, we do give deference to that, so where does that leave you?
Well, again, I do think his finding is clearly erroneous.
How do you get there? I mean, he had to pick one.
Well, for all the reasons I cited, I think all of that evidence is overwhelming, that indeed there must have been an agreement. Why would Chris ever give up his father for murder one?
No, I understand that you're saying he must have hoped for something, and that makes all the sense in the world. He must have hoped that if he does what he does, he will get something. That doesn't necessarily mean that there is an agreement between the two parties.
Well, I'm going beyond and saying more than Chris had a subjective hope.
No, I understand you are.
Yes.
I'm just saying I don't know that there's evidence of that.
Well, again, we can cite Chris's plea hearing when the prosecutor said that nothing was openly discussed. He didn't say nothing was ever discussed at all. He said it was never openly discussed. We have defense counsel saying that the prosecutor was a man of his word. We have the defense counsel explicitly saying that Chris's testimony was a quid pro quo. And he said, I want more of a quid pro quo than 12 to 15 years. But he explicitly used the word a quid pro quo.
So back to the affidavit then. If something was less than openly discussed, shouldn't that be an affidavit from Chris's counsel?
I think,
You know, and you're worried about Chris lying. He's clearly lying in one place or the other, right?
Yes.
So his perjury issue is a non-issue because he's perjured himself in one place or the other, right? So I get back to that. We don't need anything from counsel about this kind of less than open negotiation.
Your Honor, there's no way I could ever get an affidavit from Chris's counsel. Chris had a completely adverse
We have
position.
a lot of defense counsel who fall on their swords.
Well, again, we had requested an evidentiary hearing on the motion for new trial, and I think given the evidence that was before the motion judge, we should have had one.
Was there an affidavit submitted by any counsel saying that they had attempted to get an affidavit from trial counsel?
No. If there are no further questions, Your Honors.
Okay, thank you.
Thank you.
Ms. Sweeney.
Good morning. May it please the court. Elizabeth Sweeney on behalf of the Commonwealth. The motion judge, also serving as the trial judge, properly denied the defendant's motion for new trial. There's no evidence of any undisclosed promises, inducements, or rewards in this case. The court found, after reviewing the exhibits, including the civil trial testimony, the plea transcript, the transcript of the trial, and the statements of the prosecutor, that there's no issue. There's nothing that casts doubt as to whether or not there was some secret, undisclosed wink and a nod agreement in this
Is there
case.
an unfairness, though? You just said the statement of the prosecutor. So the judge decides not to have an evidentiary hearing and credits the prosecutor saying that there was no plea deal. Is there something unfair about that? That he can say no to an evidentiary hearing and at the same time put into the calculus the prosecutor saying there was no deal?
Well, your question has a bunch of different parts. First, the prosecutor's questions by the judge were not just cursory or, was there an agreement? No, there wasn't. It was a pretty long 2 to 3 page
Which way does that
question.
cut as it relates to my question?
It cuts into whether or not there should have been an evidentiary hearing as far as there should not have been, because the evidence that the defendant has shown, the civil trial testimony, the lack of an affidavit from an attorney, the lack of an affidavit saying that they were going to reach out to an attorney and get some sort of evidentiary support just doesn't exist. So the defendant hasn't made a substantial showing that there should be a hearing, that there's any agreement at all. The prosecutor denied any sort of agreement. The only statements that we have are the defendant's, Christopher's biased civil trial testimony where he's trying to get money for his family. The end result of this entire criminal scheme, and an affidavit from an attorney that allegedly overheard a prosecutor who's not even involved in this case at all. She was not the trial ADA. There's nothing that amounts to an evidentiary hearing or any challenge to the prosecutor's statements. There's nothing that cuts, against his credibility. And the judge made the correct finding in this case.
What do we make of the plea agreement, or the plea colloquy where the word open was used? How are we supposed to look at that?
I think that the term of "there was no agreement openly discussed" just refers to the statement of, we're not going to use your grand jury testimony, your statements to the police, and your testimony at trial against you. He might have hoped, Christopher Manaloulis might have hoped and wished that he would, get a benefit from his testimony, but Commonwealth v. Shand clearly states that your hopes and your wishes don't amount to an undisclosed or an agreement. And we just don't have any evidence here of some sort of agreement, wink and a nod with the
Does the
Commonwealth.
combination of that statement with he's a man of honor, does that sort of get us a little more nervous?
No, the statement was he's a man of his word,
Right, man
and
of his
it refers to, if you read that page in the transcript, refers to Christopher being held at a different facility away from individuals that might have heard that he testified against his father and his uncle.
How do we make that direct connection? How can we be sure of that?
The judge found that that's what the prosecutor, or what the defense attorney was referring to when he was discussing this about the prosecutor. And just reading the transcript, it's very clearly, it goes into this discussion of where's Christopher going to be held during this during his sentence, and they're discussing the manslaughter and where he'll be held for that, so away from the individuals that he testified against.
So we'd have to find that clearly erroneous, that fact finding.
Yes, the motion judge is also the trial judge. It sets a very high standard for the defendant on appeal. I suggest he has not met that standard of showing that it's an erroneous finding.
Do we have the plea colloquy of Chris as part of our record?
Yes, you do.
I've not had a chance to look at it. Mr. Reardon claims that the admissions that were made and the proffer made by the Commonwealth in the plea vary considerably from his testimony at trial. Is that true?
I'm sorry, I didn't understand your question. I couldn't hear you.
That basically the admissions made by Chris when he pled guilty and the proffer as to what the evidence would show if the case were to go to trial against Chris differ materially from what Chris testified at the trial of Mr. Upton.
No, I would disagree with that statement. The testimony during Trefond's trial, he does admit to, that he went there to steal the jewelry again.
Right, but we're speaking about Mr. Upton's trial.
And again,
not
at
Mr.
Upton's trial, it was slightly different. He did get into more detail about stealing the jewelry and where he was and when he heard the shots. Obviously, Robert Upton pulled the trigger, so that information, that testimony did get into a deeper detail. And then during the plea transcript, the plea colloquy for Christopher, the prosecutor does outline his involvement in stealing the jewelry and what he's observed and how the defendant was sort of the mastermind of this case and took advantage of Christopher as he was only 17 years old at the time. And his mother wanted the defendant to mentor him, wanted to assist him with his alcohol, substance abuse, and not going to school. So that information was also in the plea colloquy.
But how does that suffice for manslaughter against Chris? That what you described suffices for an attempted burglary. What was the proffer with regard to why it rose to the level of manslaughter?
That they discussed going down to Cape Cod. They discussed going to the victim's home. They discussed stealing the jewelry, and they discussed at length that they were going to kill the victim. There was information about the conversation that Dylan Laird had, that he overheard the defendant and Christopher Manaloulis and Trefond discussing this plan, and they went there, and Christopher was present. He took his clothes off, he changed his clothes, threw them away, threw away the evidence, and then drove back up with his uncle after the killing.
But Chris's testimony was that he did not plan to kill his uncle. In fact, he planned to save his uncle.
Christopher's, I wouldn't use the term save his uncle. He was there. He definitely knew that there was, that they discussed murdering the victim at length multiple times, many members of the family, and he knew what he was doing. He described how he drove there with the intent of robbing the victim. He said he turned the corner and he saw Robert Upton holding the gun and saw, 2 shots and heard him scream, "No, no, no." He certainly described that information in his testimony at the civil trial and also at Robert Upton's trial.
Ms. Sweeney, how is it that Christopher saying at the defendant's trial that there was no agreement and then testifying later, the civil trial, that there was? How's that not newly discovered evidence?
That's not newly discovered evidence because the standard of newly discovered evidence is it could not have been discoverable at trial. So in order for the civil trial testimony to qualify as newly discovered evidence, there would have had to have been a secret agreement, as the motion judge found. And his testimony, the fact that it's different, it doesn't rise to the level of newly discovered evidence where there was a clear motivation for him to lie at the civil trial. It was the end result, as I stated earlier, of this entire criminal conspiracy to get the money that his family wanted so badly. And in the end, they did.
Doesn't that raise a substantial issue under Rule 30 that requires a hearing? And that
Absolutely.
And Mr. Ridden, an evidentiary hearing, Mr. Ridden was erroneously deprived of the ability to gather that evidence?
Under Rule 30, no, that does not rise to the level of a substantial issue because, as the motion judge found, Christopher's testimony, one way or the other, he testified 2 different ways. His credibility is gone. It's non-existent. It's easily read on the transcript, and you can figure out which one is valid based on the motivations that he had when he made that testimony. For example, as I
Wouldn't
said,
it be for a jury to make that determination as to which one's valid?
the jury was presented with his testimony, and during the closing argument, the defense attorneys, argued at length that clearly there was some sort of secret agreement. So, and the jury rejected that when they found Robert Upton guilty. The questioning, the cross-examination of Christopher Minaloulis was pages and pages of, yeah, there wasn't a secret agreement here, but there was just no evidence to support that. And that's why we're here today. If there are no...
Well, the jury didn't reject it. The jury found him
The jury found him guilty,
The
but if
jury
there
could
was
have
a-
understood that there was
there's
some
a-
expectation that he would get a benefit, but they still arguably credited
Right.
his testimony. The agreement that said they would not use the evidence against him, did that mean a derivative use or just direct use?
That they would not use the evidence against him in a
Of
future
Chris,
proceeding
yeah.
absent perjury.
Okay, but was that meant only that they would not use his statements and say they are admissions, or that they would not use any leads or any information that was derived from that testimony?
I believe just the testimony, that they could use leads and information from it, but not just the testimony.
Just direct use?
Yes.
And with regard to the CSLI, there was no CSLI that came into evidence in this case?
In 2009, I don't believe there's any CSL. I know they seized a phone, but I don't believe there's any CSLI. There's no further questions. I rest on my brief.
Okay,
Thank you.
thank you.